Good morning and welcome to another Virtual Legality. I'm your host, Richard Hoeg, the managing partner of the Hoeg Law business law firm of Northville, Michigan. And today we're going to talk a little bit more about Star Control Origins, Stardock, and the Digital Millennium Copyright Act, DMCA, because I'm sure none of you are sick of talking about it or seeing it on the internet or otherwise discussing it at all. The truth be told, I hadn't anticipated spending my first week of 2019 just talking about Stardock and the DMCA and everything else, but here we are. So, like I said in my first video of the year, a little bit earlier this week, I do want to offer the following disclaimer, which is that Hoeg Law is located in Northville, Michigan, which is just down the street from Plymouth, Michigan, where Stardock is headquartered. And throughout my career, I've had numerous professional and personal contacts with CEO Brad Wardell and other Stardockians, which I consider to be, in general, good people trying to put out good software and good video games. And so I put that disclaimer out there, not because I think it biases my analysis, I really don't, but because you might. And I think that disclosure is always a good idea. And so I want to put that out there. Now, I did see in a couple places on the internet some folks referring to me as really good friends with Brad or things like that. I wouldn't call us that. I've met him a couple times, and we've certainly had conversations. We've had no conversations about this lawsuit, about Star Control claims by either side. These episodes are made completely independently from Stardock and are just my own thoughts and concerns about the way statutes and things are being used in the industry that I want to talk about. So the first thing I want to talk about is that yesterday, the original makers, Ford and Reiche of Star Control 2, defended their DMCA takedown. So again, I would recommend you check out my first video, but to give a little historical context on this, the Star Control 2 makers from 1992 and 1994 put a DMCA takedown notice on Stardock's Star Control Origins, which released last September, on the premise that it was infringing the copyright that they held in Star Control 2. Now, some folks got a little upset at me that I didn't talk about this document here, which is the denial of the request for preliminary injunction that Stardock made against Reiche and Ford's use of the DMCA because they knew that it would be used to take down Star Control Origins. And one of the comments that I had to my previous YouTube video was that, in essence, I didn't think it mattered. The comments that I wanted to make in that video were really about how I thought the DMCA was a dangerous tool to be used in this fashion and that the video game industry should be concerned. And I want to double up on those thoughts today, talking about what Ford and Reiche have now put out there as kind of the basis for their DMCA claim. But this preliminary injunction was denied for reasons which are pretty standard to preliminary injunctions. The way a preliminary injunction works is that the side that is seeking it essentially has to say to the court, hey, I'm going to be what we call irreparably harmed if you don't give me this injunction. That if you don't stop the other side from doing something, there is some damage to me that will not be able to be replaced, that I can't be made whole if you don't stop them from doing something. And they also had the combination argument that the way the DMCA works, it serves as an injunction on their own product. And I told the commenters that I was discussing this with on Twitter and on my YouTube channel that the reason I didn't bring it up is that I agreed with the denial of the injunction, and I don't think it actually impacts whether the DMCA should be changed or whether we can talk about how it's being used in this case. But the reasons I think that are the reasons that the judge gives. Most prominently, there's a discussion here that talks about, so this is all factual background, which is all very interesting, and I do recommend checking it out. I will try to link this in the descriptions to this video. But the reasons the judge gives are twofold, and they've been a little bit misinterpreted in the articles that I've seen around the internet in terms of what they're saying is the problem that Stardock has, and perhaps being a little bit angry or expressing animosity, as judges sometimes do. It's always easy to read into judgments like this, especially preliminary judgments, and try to figure out the way the court is thinking on the merits of the case. But it's very important when you're talking about an injunction or a preliminary matter of any kind to note that we're not really talking about the merits. At no point when we talk about this document are we looking at the judge saying anything about whether Star Control Origins infringes on Star Control 2 or any of the other kind of tertiary or ancillary claims that are being made by either the Ford-Reiche side or the Stardock side in the case in question. So what we're only talking about here is that Stardock moved the court to force Ford and Reiche to not have the DMCA available to them. The court said, no, we're not in the business, really, of stopping people from using federal statutes that are all validly applicable to the situation at hand, and so we're not going to do that for you. They said, and just give me 1 second here, because unfortunately my highlighter does not work on these documents. They declined to call the DMCA's use an injunction because it's not. The way the statute works, and we talked about this in the first video, is in an incentive sense. They say you are free from liability if you follow these steps. And in most cases, a lot of companies are going to say, hey, we like being free from liability. Liability shields are good. So we're going to follow those steps. You send us a notice, we're going to take it down. You send us a counter notice, we're going to put it back up. You send us a notice that you're pursuing a court remedy, we're going to take it back down. Or in this case, where there's already a court action pending, we're not going to put it back up, and we're going to wait for the court to decide on these things. So here's what I wanted to talk about, and I think this is the best argument that the DMCA preliminary injunction should be denied. Plaintiff claims that the loss of Section 512, which is the applicable section of the Copyright Act that we're talking about here, the loss of Section 512 safe harbor proves too great an incentive for service providers, causing them to take down targeted content immediately. Insofar as plaintiff questions the wisdom of the DMCA process, however, its quarrel is with Congress, not this court. And I think that is exactly right. I think there are problems with the DMCA. We've talked about in our first video. We're going to talk about again right now, especially in this case and the precedent that it runs the risk of setting for future actions in the video game industry and the software industry in general. But it is not the position of the court to say, absent some other exigent equitable circumstance, that person X should not be entitled to what is a very clearly applicable section of the Copyright Act or any other federal law. And so if you've got a problem with the DMCA, and in particular Section 512, that's something that you should talk to your congressman about. That's something you should seek to have changed. And I'm going to advocate a change in this video. But it is not something for the court to do. The second piece of this is, as we talked about at the start, you need to have an irreparable harm. You need to have something that can't be fixed. And what Stardock was claiming was that they spent a lot of money on Star Control Origins, and if you take it off the marketplace, we're going to lose all that money. And the court rightly said a couple of things, but what I found most persuasive was the fact that they said, in general, the law doesn't view monetary damages as irreparable. For the most part, you lose money and the other side can write a check. We can make you whole. It's just money. When we talk about irreparable harm, we're really talking about something else that doesn't result in solely monetary damages. So they failed in that case. And then there was also some chiding, which did make a number of the articles that I saw about the fact that Stardock elected to put that investment in after they knew that things were maybe going south with Ford and Reiche, and perhaps should have been more judicious in determining whether or not they were going to continue that investment, which is really the court dicta saying maybe we don't like you so much, maybe we're trying to say that we don't like the way you've presented yourself so far in the case. Maybe it is, maybe it isn't. Like I said, there's a lot of tea leaf reading whenever you're looking at preliminary documents, or even when you're reading the court cases when they're finished. But I would not read too much into that. So with that all being said, I don't see the actual preliminary injunction being denied as dispositive to whether or not the DMCA should be used in this fashion, whether or not the game industry should be concerned about it being used in this fashion, or anything else. But I did want to talk about it a little bit because some people did ask for my thoughts on that. In short, were I the judge, I would also have declined the injunction with at least the knowledge that I see here. Obviously, I'm not privy to all the documents. I didn't read through all of the briefs or anything like that. But what was described in this injunction, I agree with, and I would have declined it as well. So in that light, Stardock and Mr. Wardell and some other folks were saying, hey, you know, your DMCA takedown basically says we have copyright to Star Control 2, and Star Control Origins is infringing, and that's all it says. And they deliver that to GOG, they deliver that to Steam, and they get them to take it down from those marketplaces. But it's not terribly descriptive. You know, what are you talking about? The one thing that they have never claimed, as far as I know, and I think it would seem unlikely that they could claim, is that Star Control Origins steals any art assets or any specific code or any specific music assets or anything specific that would be stolen in whole from the Star Control 2 game. And that's where you usually see these kinds of arguments. You usually see somebody saying, hey, that piece of art, the way that gun looks, was stolen from game X and put into game Y. And so now I have an infringement claim against you. Now I could potentially proceed with looking at a DMCA takedown. That's not the case here, as far as I'm aware. There are certain instances on the margins where preliminary materials before the game was made available for sale, there appears to have been kind of beta references, which I think Stardock felt were Easter eggs, that maybe an Urquan ship appeared, I think, as a like a rear view mirror toy in one of the shots that never made it to the base game. And certainly you can argue that Stardock was trying to push the envelope on some of these things and maybe potentially even trying to poke Ford and Reiche. But to my knowledge, none of those things appeared in the game. I have seen posts and I have seen indications that there is maybe a direct reference to the Zachfot pick, which were a race in Star Control 2. Which may appear on a random planet somewhere in the galaxy that I didn't see in my playthrough, but I certainly have no reason to believe isn't the way that they are depicted in the screenshots that I've seen online and were conveyed to me. I certainly think those kinds of instances where you have a paragraph story blurb taken out directly, a character name, those are more potentially problematic than some of the stuff we're going to talk about today, but they represent such a small portion of the game. I don't think that's where Ford and Reiche are trying to hang their hats. Instead, they're trying to hang their hats on what we would call substantial similarity, total look and feel. Copyright is a nebulous kind of concept, so there are a number of different phrases that are used to kind of discuss the premise that an audiovisual work looks and feels too much like another audiovisual work. And so that appears to be the direction they're going. And that's why one of the things that I tweeted out, as for instance last night, was that the industry should be petrified that that is the basis of a DMCA takedown notice. And we're going to talk about it right now. But it is so vague that it would allow practically anyone to issue a takedown notice on practically anyone else, were this to be the norm in the industry. And I gave a few quotes to Game Daily Biz that talked about the fact that I don't necessarily think that is going to be the end result of this entirely, because businesses tend to be a little bit more dollars and cents focused and maybe not acting out of as much passion and emotionality as the Star Control fight seems to have gotten into. But it is worrisome if we proceed down this line. So let's talk a little bit about what Ford and Reiche have actually said is the basis for their DMCA claim. So we got here a Polygon article. Star Control creators defend their DMCA claim against Star Control Origins. The pair claim that Origins is simply too similar to Star Control 2, the Urquan Masters. And they give a little bit of the background that I just gave, talking about what they may or may not have bought in their bankruptcy auction, where Stardock got the trademark name to Star Control, although that is contested as well as part of the current suit. Certainly the name Star Control is the strongest piece of Stardock's argument for making Star Control Origins or any other kind of Star Control related ephemera. So they created this table that they used to talk about interstellar travel. They just want to talk about one aspect of the game and how Star Control Origins infringes on the Star Control 2 rights. Now, they've included a column here for Star Control 3, which is essentially a red herring. So they're trying to establish that Stardock has bought certain creative rights to Star Control 3, and they're talking about how Star Control 3 is different from Star Control 2, and why doesn't Star Control Origins match Star Control 3. The reason it's a red herring is because even if their exact story of what Stardock bought is correct, even if they did buy the Star Control 3 rights, that really doesn't mean anything in the grand scope of things. Stardock would not be limited to making a game solely like Star Control 3, just as if they never had any rights to Star Control 3, they would be limited in making any other type of game. So it's a matter of, yeah, they're trying to show that Star Control 3 went differently from Star Control 2, but that was Accolade's decision back in the day, and it's not the decision Stardock made. So let's look at some of the stuff that they say are the same. Interstellar travel uses hyperspace. The ReLU refer to our dimension as true space. Display is 2D top-down with your starship named Vindicator shown in the middle of the screen. So let's start with a couple of these. So a couple of these are names, and And I think it's clear that any given thing on this list wouldn't rise to the level of infringement. I don't even think that's what they're claiming. Although if they feel differently, I would be interested in hearing that as well. Their argument is that you take all of these together, and presumably they have charts like this or other descriptive things that they want to show for things that are outside of interstellar travel, but they didn't show them in their blog post yesterday, that take them all together, and the look and feel of Star Control Origins is so similar to Star Control 2 as to be infringing. Now, that's not a standard applied lightly because it has a lot of negative ramifications in video games. It would have a lot of negative ramifications if applied in this fashion to any industry. But when you talk about what they're showing here, they're saying if you use the name hyperspace to differentiate from true space, and you have a 2D top-down view with Vindicator shown in the middle of your screen, then you're violating their copyright. Now, a couple things to note here. One, you can see in the pictures that they've provided themselves that while Star Control 2 is top-down, Star Control Origins is not top-down. It's actually what we would call maybe three-quarters or isometric perspective. And there's no question you show two screenshots to somebody, they'd be able to differentiate the two games. So they're just trying to create a story here that talks about, hey, it kind of is evocative of Star Control 2. Vindicator is not the name of the ship. It's a ship name that I think that's the default name, but you can change it to whatever you like. I honestly can't remember whether the Vindicator name can be changed in Star Control 2. I think it can. They go on to say interstellar space is red. It has red streams of light dash and twist across the screen. Whenever you get these kind of evocative narrative descriptions of what's happening, that's where the ambiguity really comes in. Like lights dash and twist across the screen. Yes, they do. They look very different in both instances. Graphic holes in space show places you can enter a star system, showing the star in the middle of the hole. Yeah, I mean, you can see the difference in the pictures here. There's a star in a hole in Star Control 2. There's like a little solar system with little ships flying around in Star Control Origins. So again, the concept is similar. The actual execution is different, and that's usually been the differentiator between the way we treat intellectual property and copyright infringement. You can't copyright an idea or an expression exactly. So you've got different execution means that you should not be infringing. Moving on to holes in space takes you to the star system. Yeah, bumping things moves you there. Radar map shows stars and ships near you. So that's very broad and very specific. So they would say if you've got a radar map, then you're infringing on their copyright as part of a whole. You can see even in the pictures that they've provided, their radar map is green and non-descriptive and put in the bottom right. The Origins radar map is blue and has a little bit more descriptive elements and is in the top right. You can see from the two pictures the UIs are not copied. The coding isn't the same. It's a three-dimensional instead of two-dimensional asset. It's a different game. Alien ships travel through interstellar space, and if they overlap your ship, you must talk and fight with them. Yeah, if they bump you, you have to do something with aliens. Hyperspace music theme by Reiche is played in remix form in Star Control Origins. That's kind of a red herring. It works for a look and feel kind of argument, but it is worthwhile to mention that Reiche is the owner of the music. So to say that he can't license it to Star Control Origins, to Stardock that wants to use it for this purpose, would be limiting his freedom of contract in a manner that probably isn't fair to him. And certainly Ford and Reiche claim no copyright or other ownership interest in the music itself. So the request to limit it in this fashion is probably more harmful to Reiche than it is to Stardock. So that's something to consider as well. You've got positional coordinates to 1 decimal point. You've got when you run out of fuel, a helpful alien ship appears on radar screen, moves towards your ship, opens communications, and offers to help you for a price. Different prices, different conversations, different aliens, different effects. It's designed to give this feeling that they are so the same, that it's compelling because of this whole bucket of things. But any given instance is different. It's different in execution. It doesn't share any code that I have any reason to be aware of. It doesn't share any assets. Players can set autopilot to fly to their destination star automatically. Seems non-dispositive. They want to say you've got an autopilot, you've got a radar screen, you've got interstellar travel when you bump into aliens, and when you bump into stars, you go into stars. And that's Star Control 2. And were they to have their druthers, no one could make a game that has these kinds of concepts in them. And where's the line between whether you have 13 concepts that are of this vagueness or this specificity and whether you have 8 concepts in your game? And so there is a lot to be worried about from an industry level if this kind of thing were to take off on the whole. And one of the things I said yesterday was, I don't care if you hate Stardock or you hate Brad Wardell. I think it's perfectly legitimate for you to hate any number of entities and any number of people. But what I would ask as a lawyer, and what I would ask is just in general an objective analytical person, is to try to separate the personalities out. And also just to separate out from whether or not Stardock or Star Control would be the only ones affected here. Because these things have a tendency to turn on you. And certainly since this is the basis of the DMCA, you've got a problem because they have a court case that's pending that I would argue, I would view this case as weak. I wouldn't view it as non-existent. I don't mean to claim that Ford and Reiche have no case. And God knows when you go to litigation, anything can happen. Any lawyer that tells you differently is a liar. A judge could decide anything. A jury could decide anything. An appellate court could decide anything. And so it's always a risk. And Ford and Reiche, they shouldn't get kicked right out of court. They've got an interesting case to make, and I think it's one that's worth proceeding and to go through discovery and the process that the court entails. But the fact that they have sought a lawsuit, I question whether they should be able to just say, hey, Steam and GOG, you shouldn't sell this, and here's your liability shield for that. And I do have a potential language that I'd like to offer to change the DMCA to better reflect what I think the risk allocation should be. But to just kind of address what I want to talk about with where the concern should be, when you've got these lists, it's very easy to make a game look like another game. And so I want to bring up for you what I've got, which is a comparison Excel spreadsheet. And in that comparison Excel spreadsheet, I want to talk about Super Mario Odyssey and Grand Theft Auto 5. So we've got a list much like the ones they made with Star Control 2 and Star Control Origins, and you might be laughing and thinking this is ridiculous, and it is ridiculous. That is why I have presented it in this way. No one in their right mind would confuse Super Mario Odyssey and Grand Theft Auto 5. But let's take a look at some of the features of Super Mario Odyssey and Grand Theft Auto 5. Open traversal in a three-dimensional world. Button to access full map to identify player location. Map uses simple iconography to differentiate and identify activities. Players collect funds through missions and in the world. Players spend those funds in stores located throughout the world. Players customize their characters through clothing changes. Players are expected to change characters to advance through missions. Players use projectile or melee attacks to defeat enemies. Certain missions begin or end with audio-visual story progression. City environment was a prominent part of game marketing. Vocalized music tracks appear throughout. And defeat is marked not by loss of funds and not by death. If you just took that list of things, which are very similar in specificity to what the Star Control 2, Star Control Origins claim, you could make an argument that Super Mario Odyssey is infringing on some of the copyrights of Grand Theft Auto 5. But that's not the way the video game industry has always worked. It's always been an iterative process. You've always had open world, which was essentially born by Grand Theft Auto 3 in the modern way that we know it, and have taken those Grand Theft Auto 3 concepts, and different companies have built on them so that you get Watch Dogs, so that you get Super Mario Odyssey. Itself built on Super Mario 64, which informed some of the graphical and design decisions made in the Grand Theft Autos of the world, all in a kind of nebulous network of non-infringing, as has been the case before now, iterative idea making in the video game and software space. And so I think everybody's pretty happy with that. I think for the most part, everybody's pretty happy that Watch Dogs can exist in a world where Grand Theft Auto exists, and that consumers and game companies can have the option of making those two games. That everybody's pretty happy that the dialogue wheel that first appears in Mass Effect might appear in another form in a different type of game, or that the way decisions can affect the world in The Witcher might appear in Assassin's Creed Odyssey, and that we can continue to kind of broaden our game experiences from the iterative process of making these games. And that includes what you might call kind of clone games, games that are essentially built off the back of another concept that maybe somebody thought they could do slightly better. In this case, Star Control Origins has a completely different plot line. It has completely different aliens. It has a completely different galaxy. It has different ships. It has different ship builders. It has a different way of collecting minerals. It has a things that you can put in your ship that change its capabilities, none of which appear in Star Control 2, and Star Control 2 is one of my favorite games of all time. But if you want to call something infringing, in my opinion, you should really be talking about stealing assets. You should be talking about stealing code. And if you start to really go into look and feel and kind of nebulous concepts of what the experience of this video game is and whether or not someone else could get close enough to it that they should be prohibited from making a game that uses similar concepts but twisted in a new and different and hopefully better, but sometimes worse, way, then you're going to have a tremendously chilling effect on the innovation throughout the industry. And one of the things I think is happening online with this case in particular is that a lot of people hate Stardock and a lot of people hate Brad Wardell. And what I would ask is to really kind of play out how this concepting, how the DMCA, how a look and feel kind of stronger copyright paradigm in America is going to affect the industry at large were it to take off, were this to be the precedent-setting case. If Reiche and Ford win this case, if they had a DMCA takedown for however many years it takes to get this case to the finish line, and they were to win this case on the merits, to say, okay, yes, Star Control Origins infringes on Star Control 2. It's not the little guys. It's not the independents that are going to suddenly be able to fight for their rights against Activision and Electronic Arts and Sony and Microsoft. It's exactly the reverse. So the problem with the DMCA is that it uses the legal system as a cudgel. It uses it as an imprecise sledgehammer to force people to do what they want them to do. And that's a problem that I talk about regularly with my clients, in that the person with the most money, the person that is most able to eat the costs of litigation, to say, yes, I can pay a law firm for 2 years to do discovery, to send documents your way, and to make trouble for you, they can now attack their competitors. The DMCA has always been this way, but this is really the first time we've seen it launched against a full price title of kind of equal comport with, Activision presidents of Activision subsidiaries. And so this is an escalation that I think the industry should really take note of and separate it out from whether you think Star Control Origins is bad, whether you think Stardock is acting bad, whether you hate Brad Wardell, all of that stuff. Instead, think about the indie developer that has a good idea that maybe looks remotely like some idea that appeared in one corner of Mass Effect one day 10 years ago, and Electronic Arts saying, here's a DMCA takedown notice and we're going to sue you for look and feel, and good luck paying for your lawyers because we can hold this up in court for a long, long time. Because that's what's far more likely to happen if this continues to accelerate, if the DMCA isn't fixed, if we continue to go down this road. It's the people with the stacks of money, it's the people with the poker chips at the table that can use that leverage to make trouble for the little guy. And I like the little guy. I like iterative process in video games. I want to see it continue. And so I think we really need to take a look at what it is the DMCA does, how it could be fixed. We talked about it earlier this week, so I'm going to skip a little bit of it. I want you to reference the video before for a kind of deeper dive into the DMCA if you're interested in kind of the more logistical nature of the law. But what I wanted to discuss is the way the counter notices work. So the way this works is that Steam and GOG are worried about liability. We like the internet the way it works, but we want to have people putting videos up on YouTube. We want to have people putting posts up. We want to have people putting video games up in our marketplace. Everybody loves the internet. But Steam and GOG and YouTube say, hey, okay, that's good, but we've got 1 million people. Some of these are bad people. And what happens if they're stealing other people's stuff? And in 1998, Congress passed the Digital Millennium Copyright Act. They said, okay, yeah, that's a good point. Here's how it's going to work. If somebody thinks somebody else is stealing their stuff, they're going to send you a letter. When you get that letter, you immediately take it down. Nobody can sue you. You're free and clear. Great. Steam and GOG say, yay, happy. All right. If the person that originally puts up that video game or puts up that YouTube video or what have you says, no, that guy is full of it, I own the rights, here's a counter notice, then you can put it back up and nobody can sue you. And they're happy. They said replaces the removed material and ceases disabling access to it not less than 10 nor more than 14 business days following receipt of the counter notice. But here's where the DMCA loses the plot a little bit. It says, well, yeah, you can't get sued for replacing it unless your agent first receives notice that the person that originally sent you the letter, the person that's claiming infringement, has filed an action seeking a court order. Now, why is that a problem? The primary reason that's a problem is that anybody can sue anybody for anything. And for the most part, while some things are going to get kicked out, intellectual property issues in particular are nebulous enough that a lot of things are not going to get kicked out terribly quickly. And the big dogs know this. They can use their money, they can use their lawyers on retainer to go and seek a court order when they like. And it doesn't matter what the merits are. The DMCA does not speak about whether your action is frivolous, whether you have any chance of winning it at all. And I don't want to suggest that Ford and Reiche don't have any chance of winning it at all. I think they have some chance. I think if I were to be forced to bet on the winners of this particular proposition that Star Control Origins is infringing on Star Control 2, I would bet on Stardock. I think they have the stronger case, but that doesn't mean it's a slam dunk case. But it does mean right now, the way the DMCA works, that because Ford and Reiche have sought a court order, they can incentivize strongly Steam and GOG to pull the game down, and they have. And I would argue that that's probably not the right standard here. And I would argue that for a couple reasons. One is, in terms of damages, the Copyright Act already protects against infringement. That's actually what Ford and Reiche are suing on, an infringement by Star Control Origins and by Stardock in general on this basis and on a couple other ancillary bases. And the Copyright Act says, yeah, okay, if we find that there was infringement, they owe you the profits they made on the stuff they sold that was yours, essentially. And so Star Control Origins being out there, or anything else being out there from Stardock, is essentially accruing a ledger of liability that Stardock would have against Ford and Reiche if they were to ultimately win their case. So they don't actually need to take the game down in order to be made whole, in the same manner that we talked about with denial of the preliminary injunction on the case in question for Stardock just now. So they're already protected monetarily. Now, they might have an emotional interest or another psychological interest or a strategic interest in having the game removed, but I think that is lesser than the fact that they are at least mostly protected on the monetary side. But what's not protected against is companies that are dealing with either frivolous lawsuits, of course, and I'm not claiming this is a frivolous lawsuit, but lawsuits that maybe don't have the best chance of winning, a weaker case, a case where they don't get to the 50% level of what was more likely to win on the merits. And certainly I sit here and look at what Ford and Reiche have provided so far and say, I don't think they have a high likelihood of winning on the merits. Now, a judge could disagree. If they did, I think that kind of changes things. You know, if you've got a court that says, no, I can make a preliminary determination based on both of your pleadings that I think there's a good shot that Ford and Reiche are going to win this case, I think that's a different thing. And so what I would propose is a change to the DMCA. Now, this is a bit of the lawyer in me. This is a bit of the law school in me. I look at laws, I look at statutes, I look at regulations, I look at contract language all day, and I don't take it as a fait accompli. It's not set in stone. It wasn't given by divine writ or descended upon from high. And so I look at what might be better, what could change in it. And here's what I would propose. So you see here we've got the language that says they have to replace it unless they get notice that the person that originally claimed the violation is seeking a court order. I would change that around. I would say they have to replace it, provided that delivery to the service provider, that's GOG and Steam, by the person who originally submitted notification under subsection C1C, so that's the original claimant of infringement, of a preliminary determination by a court of competent jurisdiction that such person is likely to succeed on the merits of an infringement claim against subscriber. So the court has determined, not fully, hasn't gone through all the discovery process, hasn't gone through all the evidence. These are preliminary motions, just like you saw in the preliminary injunction document. The court has looked at things and said, hey, looking at this, I think these guys have a good shot. They're likely to succeed. When you've got that in hand, I think you should be able to submit that to Steam and GOG and say, hey, look, we got a court order. I think we're likely to succeed. We haven't gone through the whole thing. We could potentially still lose. But once a court has made that determination, I think that should constitute essentially a blocking notice of the counter notice. So I would envision this saying that notice, that you've got a preliminary court determination, it shall constitute a renewal of the original notice, not subject to counter notification. And the service providers, Steam and GOG, will be entitled to the limitations on liability. They won't be able to be sued for removing the content at that point in time. In other words, it would mirror the kind of court process that we already have in place without short-circuiting it in favor of claims that might not have the best chance of winning. Now, you've got a marginal difference in timing in terms of the claimant would have to go seek a preliminary motion as part of their court process, and it would take a little bit of time. It would take a similar amount of time to what you just saw was the denial of the preliminary injunction for the DMCA at all. But I think it would better match the different incentives of the parties in a case like this. It would be more conducive to getting society in general to a place where somebody that wants to use a DMCA takedown, somebody that wants to use these statutes still has the opportunity to do so, but we have to make sure that they have at least some legitimate interest. And I think that threshold could be changed around. If you want to say change it from likely to succeed to even, a good chance of succeeding or something along those lines, I think that would be worthwhile debate, and certainly a legislator type debate. But I think what we've currently got, which is that you've decided to sue, really only allows the DMCA to be used at its maximum leverage by folks with a lot of money or that are litigious by nature, and doesn't necessarily incentivize serious claims against particular intellectual property. And I think you'll see that borne out in the future if we have this case go on. And I really do think the games media, the internet in general, should really focus on separating out its own beliefs about the personality of the players, whether you dislike Wardell, whether you dislike Ford and Reiche, whatever's happening here. I think everybody should take a step back and really take a look at how the DMCA is being used here and reflect on that. Because there are a lot of bad things that can happen from here, and I am not suggesting for 1 second that the preliminary injunction should not be denied. I'm not suggesting really that Ford and Reiche should not have used this tool that is available to them. I'm suggesting that the tool should not be available to them, and I think that's a worthwhile conversation. So that's really the follow-up to the original Stardock video from earlier this week. If you have any comments, feedback, suggestions, this has proven to be a hot-button topic this week, so I'm sure some of you will. I am always willing to take those feedback and suggestions. And thank you so very much for watching. Have a great weekend.